All right. Um, this is Brian Parker from collectionstopper.com. And I say that right off the bat because a lot of people have been asking me, why aren't you doing stuff on suing debt collectors? And I thought, yeah, how come I'm not doing that? So I think what I'm going to do is a little something different this time and showing you how to go after a specific debt collector rather than just saying something general. With that said, generally there are two types of cases. There's a creditor case, that's where Citibank or Wells Fargo or Bank of America has your debt and is suing you directly. So Citibank is suing John Smith. If Citibank has a large portfolio of debt that they consider uncollectible, usually that means a debt has gone delinquent older than 6 months. It's then charged off and they will sell it to a debt buyer, the second classification of companies that I sue. So I sue debt collectors, debt buyers, debt collection law firms, creditors. And it's all the same to me. And there will be another video coming up that's going to be really cool. You may want to do some research. I know I do it every day on the concept of securitization. That is a new avenue that I'm exploring, and I've done a bunch of lawsuits just to see how the other side is reacting to this new concept, and it's going quite well. My goal being to obtain the kind of recoveries that I get from suing debt buyers. Debt buyers pay pennies on the dollar to companies like Citibank or Wells Fargo or Bank of America just to buy their old charged off debt. Now they're paying pennies on the dollar, but they're also getting crap paperwork back. But that's okay to the debt buyer or the debt law firm because they know the odds are, and I've done the math, they've done the math before me, you'll be surprised how AI it all is and algorithms. They know that 85% to 90% of lawsuits they file are going to get defaulted or easily settled for the amount that they agree to, which is thousands of dollars more than they paid for the debt in the first place. And again, as I've said in previous videos, I live in the 10%. I live in the 90 to 100% where a client gets a hold of me and wants out of the debt for various reasons. Admittedly, a lot of my work, good work that I do for clients. In fact, if you want to go to something really cool, that just some beautiful lady sent me this video out of the blue. She's 78. She's not doing well. Her husband's doing worse, and she's been plagued by debt buyers and debt collectors for a decade now. And the work we did, as she said, changed her life. And she just sent me the video, say, do whatever you want with this. So it's on the front of my website at collectionstopper.com. Hers was a case similarly that I enjoy going against, which is the debt buyer. Debt buyers, as I said, pay pennies on the dollar. So if they bought something it defaulted at $20,000, they probably paid a couple $100 for it, and they'll go for the $20,000 through the law firm that gets a percentage. So everybody's all in on getting as much money as they can, unless they have to go through me or you if you're so inclined. And going through me means you have to prove you own that debt. That's what you need to do to beat these debt buyer lawsuits. Show that they don't own the debt. And it's really easy because the work involved in showing how the current owner of the debt perfected the chain of title all the way down from the creditor is, I've yet to see anybody do it. I have yet to see in 20, 30 years of doing debt collection lawsuits at the federal level, state level, different states. I've done it all over the nation. I had a national debt collection apparatus set up, meaning I was suing debt collectors nationally. So I've seen it all, done it all, I think, and I've yet to see one debt buyer, debt collection law firm bring a case with a perfected chain of title. Today we're going to look at a company called Velocity Investments, LLC. So there's many debt buyers out there. That's a favorite of mine. Right now they're buying up old debt from a company called Cross River Bank. So if you go online, you want a quick sort of a payday prime rate loan, you can get a real quick loan for 20, 30,000, whatever you need, and they'll give it to you and you'll sign your life away. And if you default, they'll sell it to Velocity Investments all throughout the nation. I go after them here in Michigan and also in Florida. And it's the same apparatus. They file a lawsuit against my client. They claim they own the debt. And then they add some paperwork, what's called a bill of sale. I'm going to have to go old school here if I can. They add, can I do this old school? Yay. It's a bill of sale. And this is an actual bill of sale that they attach to all their lawsuits. And in the bill of sale, they say this side, Velocity over here owns the debt. And they got it from, if you can see without me blurring you out, a company, I suck, a company called Upstart Pass-Through Trust, which is not in the chain of title, but as you can see, Upstart Pass-Through Trust claims to be sending all the rights, title, and interest of certain charged off loans. Remember I said delinquent loans after 6 months turn into charge off loans. And they're claiming they sold it to Velocity, the company that sues my clients from a debt they bought, they claim, from a Cross River Bank. But that ain't really what is happening. And if you look at the bill of sale, boy, it's good covering up my face. You can see that while they're passing all this stuff to Velocity, who passed the debts on to Upstart Pass-Through? We'll never know, because there is no assignment from the originator or the original lender, which is Cross River Bank, who in another document claims that, but at a later date from the bill of sale, claims they sent the document to Upstart Networking. And then the law firm writes a complaint that says, hey, Velocity got it from Upstart, without even mentioning Upstart Pass-Through Trust. And it turns out the only document of proof showing Velocity got something, even though the Upstart Pass-Through Trust has no assignment from anybody else showing it got something to send that it claims it's sending, it's convoluted. It's the only document that Velocity has to support that it got something from somewhere, maybe. And by the way, that line I just used, I put that verbatim in my brief just to be folksy and have the judge ask me about that. And that's another video of how to write a motion, which is coming. Upstart Pass-Through Trust Series 2021, which is in the bill of sale of most lawsuit attachments from Velocity, has no right to anything unless it can show it received something. What it is, it's just a trust that the originator, Cross River Bank, dumped a bunch of debts in. Let's say the debts were $100, they get $80. Now Upstart Pass-Through Trust owns the debt, and Cross River takes it off their balance sheet so they can get a better interest rate to borrow money to sell it to my clients. The default, whose debt is then sold to the trust, who then doesn't sell it to anybody but Velocity. Maybe it's just a mess. And I say it like that, and that's kind of the way I say it with juries, so that they get confused. And then I say, if you're confused, I'm just telling you the way it's being presented in the lawsuit. So there's a means. Why I'm sounding confusing is because I want to sound confusing, because if this was a clear, perfected chain of title, there would be no confusion. So what I did is I put my show notes, as I always do, on my website in the podcast plus at collectionstopper.com. And you can see 4 lawsuits filed in Michigan with the weird documents, and see for yourself. What I'd like to do, I'm going to give you a task and then I'm going to grade you. No, I'm not. So write down on a piece of paper when you're figuring out how to win these cases. Who lent the money? It's Cross River. Who then received the debt? Well, the only document we have is that Cross River sent it to Upstart after the bill of sale is claiming Upstart Pass-Through Trust Series 2021 sent it to Velocity. Later on, Cross River says they sent the debt to Upstart, and then the lawsuit says Upstart sent it to Velocity. Even my saying that without you looking at the documents, you can tell there's something rotten in Denmark. And it's all like that. And again, the philosophy is we're going to file 100 of these cases, 90 of them are going to get defaulted, so who cares? When I get involved, I go straight in on this. I go, just show me the ownership. To sue somebody in a debt collection lawsuit, you must have standing, meaning you own the debt. You must prove. For example, it's very simple. If I sell you my car, I have to write down my name, your name, you sign, I sign, the VIN number of the specific vehicle. Otherwise, I can't do anything. I have to have a correct title. When you are fighting these lawsuits, lawyers or real people, where's the title? Look for the corrected chain of title. And if there's one missing link, the title's as good as its missing link. And in these cases, there's no real chain of title to Velocity Investments. But again, Velocity doesn't seem to care. How do I know? Because they attach an affidavit, a sworn under oath affidavit saying, yep, Upstart gave it to Velocity, and no mention of anything in the bill of sale in an affidavit. So what did I do? I deposed that person. It's one person. I think her name is Aaliyah Rivera, and she signs all these affidavits throughout different states claiming certain things are true, sworn under oath with the words, I realize that I'm committing perjury if I'm not telling the truth. So I sit her down, I do a deposition of her, and guess what? She admits that she didn't really write the affidavit. The law firm sent it to her. They kind of told her she got to sign it. And then you question. What I do is I question specifically, again, another video of how to give a deposition. You question them specifically on each thing they said in the affidavit, which they've probably never read. And you can see as you're deposing this person is everything to the lawsuit. The lawsuit rests on the affidavit. Otherwise, it isn't what's called an account stated lawsuit, at least in Michigan. And she hasn't a clue. I've never seen actual deer in the headlights from a person, kind of eyes. It was really uncomfortable, not for me, just asking her to back up supposedly what she said she swore under oath. It was uncomfortable. But this is what you do in that 10%. That's where you have some fun. So I'm going to let you have some fun and put it all on my website, exactly how I attack Velocity Investments, which she admitted may not even be the name of the company that employs her, that she claims employs her in the affidavit. In fact, I said, who signs your paycheck? And she said, some other company. It's like a portfolio group. She can't even say who she works for in this affidavit. That judges are going to take as gospel if you don't do a counter affidavit. I'm going to do a video on how to properly do a lawsuit response and the ways to do it as far as debt buyers and debt collectors and even creditors are concerned. But I always do what's called a counter affidavit, and you could probably find them on my website somewhere, but I'll be more specific and put it on my podcast plus section once I do that video, and I'll have the show notes for you. But the lion's share of what I want to tell you today about Velocity Investments is they don't own anything that they claim to own, and you owe all the money. It gets them quite angry because you talk to the attorneys and they're furious because they have documents that show your client making payments on the debt. And then they ask me, why doesn't your client owe this? And it's the same line I give judges. I'm not saying my client doesn't owe it. She doesn't owe it to Velocity. And if they don't prove it, and use that line in court. Sure, my client owes the debt, just not to this company, Your Honor. And it's a winning argument. Because up until that point, the judge is probably thinking, why don't they just pay this? They signed up for it. That looks like her signature. And that's not even true either. It's just an electronic signature. And it isn't even meeting the definition of what's required minimally in the state of Michigan to be an electronic signature. It's just a mess. But again, it's all a numbers game. They file 90% of these and they'll get defaulted. They don't have to prove anything. And the judge looks at the affidavit attached to their lawsuit and goes, well, all right, they've got enough here. So you just got to call them on their BS. And it's real easy because I don't have to do any work. I think you can see the writing. I put that in my response with the judge, even with the writing. And I want the judge, and I'll make hay. I'll yell and scream. I'll have my client pay this today if you can just show me who gave the debt, depending on the case, to this upstart trust. Just the name of that trust opens up so many problems, because if the debt's in a trust, then it isn't able to be sold to anybody. Again, we'll get into securitization and why it's so important in these sort of payday, cash quick loans. Without securitization, putting the debt in a trust, these companies, Cross River Bank or Prestige Funding or all these companies that sell, that provide people these quick money at high interest rates, operate on the form of securitization, and they couldn't function without them. So your job is to show the chain of title in order to have and sue upon a debt. You must own it. That's easy, right? But if you're a debt buyer, you've got to show the chain of title from the original creditor, in this case Cross River, to Upstart Network, to somewhere Velocity, and somehow throw in Upstart Pass-Through Trust. It's a mess that they can't solve, but like I said, 10% of the time they don't have to. But if it's your case or your client's case, you got a winner. I also counterclaim against Velocity, because I'm going to have them pay me all my attorney fees or costs, or leverage that to get a full wipeout. I don't settle for anything. I am gunning for the entire debt to be gone. Whether it's a student loan, a Velocity loan, or an average credit card debt that was bought by someone at pennies on the dollar, that's always my goal. And I do try to eliminate a lot of debt. And how do I do it? With their paperwork or their lack of paperwork. And that's generally how it's done. I give you this information purely as education and information. You're not my client. I'm not telling you how to live your life. In fact, most of my, as I always touch upon relationships, most of my failed relationships are as a result of my telling people what to do. So, or trying to fix stuff. I'm a fixer. So you can listen to me or not listen to me. You're not my client. But you may want to consider a different approach if you're not getting debts eliminated from companies like Velocity, or getting them to pay you and also getting the debt eliminated. It's out there. Also include, when you get anything like that settled, get it off the credit if they've reported. That should be mandatory in your settlement releases. I can't show you all mine because they're all confidential. But rest assured, that should be your goal. Go to collectionstopper.com for the podcast, plus notes for all the show notes for everything I just said. Just go to the front page and see that wonderful lady that left that great testimonial. I'm actually changing some things just because of what she said to me and about me. just a sweet lady that you'll see what we do is worthwhile. She thinks that we saved her life and gave her a new one. And at 78, that's a nice thing to hear. But you can do the same things for your client. I talked about why do we do this. We do this for the rewards that are, I guess, sort of spiritual and soul enhancing. The money pays our bills. We're going to make a certain amount of money a year, but this stuff where you're helping someone, just go to that video and you'll see that's what I hear commonly, and it enriches me, enriches my soul. And I want that for you. Well, I hope I helped you. If you want to know anything more about velocity that I haven't touched upon, I always finish these just like I finish motions, just like I finish trials, wishing I'd remembered to do one thing. I touch upon the differences of creditors versus debt buyers in those show notes. I don't want to bore you because I like getting straight to the meat of the act. But just remember, velocity can't prove it owns the debt to have standing to sue the client. And that's the basis of why you're going to make someone really happy, hopefully like Nancy did, like Nancy is on the front page of my website. Thank you very much for listening. Subscribe, like, and as always, if you want to hear something that I didn't touch upon about anything in this realm, I'll do a video on it. Just give me some ideas. And this head's got 30 years of experience that I want to put into 30 minutes for you. Thank you very much. Have a good day.